Hello viewers, I am Dr. Divyansha Kumar, Assistant Professor of Management, Amity University, Punjab. Today, we'll discuss the convergence of law and economics. Let us first understand the concept of economics and law. Law and economics are two subjects that are intricately intertwined. Concepts like custom, future, sovereignty, and scarceness are related to both law and economics, similar to property or contract concepts. According to Black's Law Dictionary, law is a corpus of norms of action or behavior that have binding legal force and are imposed by a governing authority, and legal systems are the institutions on which laws are formed. Legal systems can refer to either a collection of rules guiding the authority of the law or a systematized expression of the governing body. Economic growth and development can have different meanings, but in general, they involve improving the country's economic well-being by making it more affluent. Now, economic development encompasses variables that contribute to the economy's welfare, such as development of infrastructural facilities, in the addition to the quantifiable outcomes of economic growth like an increase in GDP. Economic development is the process of economic growth. The law and economics movement incorporates economic theory and approaches into legal practice. It contends that economic reasoning abilities offer the best potential for justified and steady legal practice. It is without a doubt one of the most well-known legal principles. The law and economic movement offers a comprehensive theory of law and a conceptual tool for understanding and enhancing its practices. According to popular belief, law is the best understood as a social tool that encourages economic analysis and efficiency and may influence legal practice. Furthermore, it considers how legislation can enhance market conditions. Both economics and law provide a framework for modeling legal conclusions as well as common aims for bringing together disparate sectors of legal activity. Putting together economic and legal theories has also led to a new research topic in behavioral economics, like how rationality affects people's behavior in legal situations, public choice theory, like how group behavior should affect law, and game theory, like how to plan your actions strategically in a legal setting. Law as an independent practice. The bulk of classical jurisprudence theories seek to identify the essential or critical characteristics of a legal institution. Legal positivism and Dworkin's law of integrity are two of the most influential. While they disagree on the definition of law and legal reasoning, they do agree on many crucial underlying assumptions that control the findings of two philosophical investigations with broadly equivalent objectives. As a result, comprehending some of the assumptions shared by many jurisprudential perspectives is critical. To begin, both theories concur on the conceptual nature of law. Both believe that a philosophical theory of law must describe the essential qualities of efficient legal practice in order to fulfill the role of philosophical jurisprudence. Indeed, most philosophical debate concerning law indicates that jurisprudence core objective is categorization. Second, both legal positivism and law as integrity benefit from particular analytical and linguistic philosophical approaches in order to arrive at a thoroughly explored notion of law. These tactics entail examining and explaining how people commonly speak about law, as well as meticulously dissecting social behavior to identify the legal from the non-legal. The third widely held belief is that comprehending the necessary and sufficient qualities that make a rule or declaration into a law is the best way to grasp legal practice. Once researchers discover or approximate such a combination of required and sufficient circumstances, they can understand the basic characteristics of specific legal procedures. Instead of using this method, law and economics academics have approached the study of law from a different angle. An economic examination of legal activity is recommended instead of seeking to identify different conceptual properties of law. This proposed conclusion is that, like other social activities, legal practice is best understood through its role as a social instrument supporting economic efficiency. Let us now understand the utility of law to promote economic efficiency. Now, instead of focusing on the distinctive and distinguishing elements of law, the practitioner of law and economics considers law to be a social tool that must be evaluated effectively. The practitioner of law and economics stresses the location of law within society's basic and common economic framework, rather than emphasizing its distinctiveness as an institution. The most common descriptive assertion related to law and economics is that legal procedures are best described as tools of promoting economically effective social interactions. To comprehend this assertion, it is necessary to analyze some of the fundamental notions included in the economic thinking models. Fundamentals of economic reasoning are: to appreciate the law and economic movement, a set of fundamental ideas is necessary. According to the most fundamental principle in economics, people are rational maximizers of their own satisfaction who respond to incentives. A reasonable maximizer of personal satisfaction balances means and goals as best he or she can. It is important to remember that, as previously said, economics is concerned with non-monetary as well as monetary gratifications, because every potential pleasure is incorporated into the calculus of economic satisfactions. It may be evaluated using economic or means-end rationality as well as the cost-benefit trade-off. Economic reasoning is typically used to improve efficiency. A more efficient allocation raises the net worth of resources. Efficiency in resource allocation differs from equity, which is concerned with equality in wealth distribution. Voluntary transfers of products may frequently boost economic efficiency, since some individuals place a higher or lower value on some things rather than others. A freely entered in contractual relationship is the most typical example of a transfer improving efficiency. The exchange results in a net gain in economic goods because one party to the other transaction values money more than the item possessed, and the other party values the item owned more than the asking price. Everyone is in a better place than they were previously. According to some economics, such a contractual trade is ethically ideal since it adheres to both Kantian and utilitarian moral theories. They argue that it is consistent with Kantian beliefs since a contract is viewed as an example of interaction between free and rational agents. It is compatible with utilitarianism since the notion of maximizing wealth translates readily into enhanced usefulness. Economists use a range of terminology to describe the potential consequences of economic transactions. Pareto optimality, for example, is defined as a point at which resources are distributed so that no one is prepared to trade farther. The ultimate goal of a succession of Pareto's superior movements is Pareto optimality. a Pareto superior change benefits at least one person while harming no one. There are no losers in Pareto improvements since no one is worse off after the transaction. Even if there may be many alternative Pareto optimum endpoints, in addition, economists established the idea of Cadler-Hicks efficiency to compensate for barriers to freely negotiated trades. When the overall economic advantage surpasses the cost, Cadler-Hicks efficiency or potential Pareto superiority emerges. In other words, the improvement in the economic efficiency are significant enough that the winners could pay the losers in the new distribution of products and still come out ahead. Now understand the promotion of economic efficiency through law. According to law and economics movement, law should be considered a tool for increasing economic efficiency. However, can the rule of law encourage efficient transactions? One strategy is to aid in avoid market failure scenarios. Monopolies are an example of market failure, a situation in which one party profits more from a good than a healthy market would allow. The law can be utilized to guarantee that monopolistic situations are difficult to create and sustain. Another way legal systems can ensure economically efficient transaction is through the enforcement of lawful contracts. Court can provide contract parties with confidence that the other party will perform the agreed upon task by ensuring contractual compliance. Ensuring contractual compliance is particularly crucial when the parties' responsibilities need to be fulfilled at different times. However, certain instances of market failures are less visible, and the legal remedies to address them are more nuanced. Externalities are a difficulty in market transaction. Externalities occur when the cost of a good is not fully reflected in its market price. For example, a manufacturer may not be required to incorporate environmental cost into the selling price of its item. In this case, parties are involuntarily burdened with certain expenses because the market price of the product does not reflect its true cost. According to Paigu, legal mechanism should be used to impose a marginal tax on the offending party to internalize any externalities. An economist, Chaos, argued that while this conclusion was justified in certain situations, it was overly broad. Chaos stated that in a market where transactions are free and people do not behave strategically, right assignments are unimportant since the results will be economically efficient from any starting point. In other words, if there are no transaction costs, the assignment of entitlements is irrelevant to the objective of allocative efficiency. According to the chaos theorem, there will be no need for the law to internalize cost in such a society since individuals will bargain for the most efficient and feasible distribution of products. However, outside of conceptual perfect markets, transaction costs such as information cost, opportunity cost, and administrative expenses always exist. When transaction costs are significant, the allocation of property rights become crucial. As a result, securing economically effective exchanges will rely heavily on enforcement and distribution of legal entitlements. The legislation can promote economic efficiency. Is it possible to explain all law as economic in nature? It may come as no surprise that legislation is frequently utilized to facilitate efficient trade. It appears that stating that the law is best described in economic terms is a stretch. It is irrational to believe that all legislation is predicted on market notions. However, economic analysis of law may see such different categories as contract, tort, and criminal law as all being grounded on the economic aims, giving law a more unified foundation than other theories can. According to Richard Posner, tort cases involving private harm may be understood as contractual by seeking hypothetical boundaries that the parties to an accident would have agreed to in advance in order to deliberately create the accident. Furthermore, criminals are deterred by the potential of punishment only if the gain provided by the illegal action is outweighed by the possibility of punishment, multiplied by the amount of punishment. Now, scholars have had some success bringing economic analytical techniques to topics that appear to be everything but economic. Researchers have discovered that even evidentiary standards and legal ethics possess economic characteristics. However, it may be argued that an economic explanation of the law fails for two reasons. For starters, it does not sufficiently reflect typical legal notions as descriptive research. Second, as an analytical inquiry of the necessary circumstances for the legal practice, it may be unable to account for the internal point of view that Hart saw as critical to a sound understanding of law. This has been noted as a fatal flaw in the endeavor by more analytical approaches to explain law through economics. This may be bringing traditionally philosophical ideas into a totally new endeavor, but the reality is that it is frequently difficult to determine what kinds of theoretical claims are being made in law and economics. If the claims are of thorough descriptive accuracy or of the need and adequate conceptual underpinnings of the law, it is most certainly a failure. Whether or not economics and law are a precise or even conceptually necessary description of law as a social institution, and whether or not they suffice as a comprehensive analysis of law, it could be argued that in any case, law should adopt economic efficiency as the central goal guiding judicial decision making. Coming to the economic theory and normative law, though intellectually insufficient, economic analysis better explains the actual outcomes of the legal system than any other theory. However, it is important to note that the law should not be intentionally utilized for this objective. It is possible that the law might be better employed to explore concerns of fairness, obligation, and alike. Law and economics experts have argued against such a result. Now, there are two kinds of arguments. First, the definition of words such as justice or obligation are so ambiguous and disputed that using such conceptions as the foundation for judicial decisions provides no assistance at all. While such notions are unhelpfully complicated, it is maintained that the concept of economic efficiency and the instruments of economic analysis are sufficiently apparent to give the judge a strong and predictable decision-making basis. Due to the institutional limits, the law is better equipped to make decisions based on efficiency rather than fairness or responsibility. This might be true if justice concerns are so complicated that they entail information that courts are fundamentally incapable of processing. Second, some argue that law should be seen as a tool of maximized contractual arrangements because justice is typically achieved through voluntary engagement in contracts. In this circumstance, legislation can be beneficial when transaction costs are so high that effective contractual partnerships are unattainable. Posner claims that governments can increase economic efficiency by distributing property rights to people who would have gained them through market trading if transaction costs were lower, meaning that the legislation should result in allocation that are similar to the outcomes of a well-functioning market. Furthermore, prominent of the economic legal analysis assert something that other jurisprudential traditions cannot. The analytical tools supplied by law and economics have spurred the emergence of new productive areas for analyzing legislation. Let us now come to the significant developments. Another argument for the economic study of law's fertility is that it has generated a variety of other techniques that are useful in analyzing legal structures. Among the most important are the findings of behavioral law and economics, game theory and public choice theory. The first one, which is the behavioral law and economics. Behavioral law and economic practitioners investigate the human constraints of means-end rationality. The idea of limited rationality is one of the consequences of behavioral economics. Bounded rationalities implies that information is not processed in the accordance with the model of perfect means-end rationality, but rather is wrapped as a result of the limitations of our cognitive skills. The endowment effect, for example, is regarded as a behavioral restriction that affects accurate property value, a key part of negotiating efficient results. The effect states that owning item causes an unjustified cognitive overvaluation of them. Another notion is that the availability heuristic distorts our cognitive capacity. The availability of powerful imagery, according to this, may cause us to overestimate or underestimate the real frequency of occurrences related to the picture. Graphic representations of a very implausible damage, for example, may have a greater influence on behavior and require inappropriate use of resources than statistical data, indicating another similarity, undesired harm to be more prevalent and easier to avoid. Such outcomes may have a profound impact on the jurisprudential practices. Judges, for example, may be unduly affected by the availability of heuristic as the rest of them. As a result, victim impact statements may be essential corrections for processes if the appearances of a well-presented defendant is court skews the findings of the judge or jury. Being aware of such a cognitive deficiency may allow you to adapt your legal thinking and conclusions accordingly. Finally, lawmakers may be able to draft more effective legislation if they are aware and utilize universal cognitive boundaries. Next is the game theory. The phenomena of strategic action is added to economic modeling by game theory. Because of the competitive nature of many social interactions, strategic actions are taken. People adopt strategic activities because they anticipate how others will respond. A person who wants to buy something cheaply, for example, may appear uninterested in order to not expose his or her actual interest to the dealer. The addition of analytic approaches dealing with strategic action improves legal economic analysis greatly. For the chaos theorem to work effectively, it must eliminate strategic activity and simply assume collaboration. However, it appears that legal activities are frequently and profoundly involved with and inspired by strategic reasons. Common sense tells us that total open cooperation is not always the best method to attain one's objective. The contradicting parties negotiate the majority of the steps involved in producing a solid contract while considering future strategic actions. Including the possibility of strategic action in the design of legal norms helps ensure that the rules do not have unexpected implications. If the privilege against self-incrimination could be used to infer guilt from silence, it would significantly diminish the value of the protection. As a result, courts have not only prohibited remarks on the refusal to testify, but have also mandated that jurors, at the request of the defendant, draw no conclusion from such a decision. Furthermore, nothing that lawmakers may have chosen certain phrasing for a statute for strategic reason may aid in directing the right purpose of judicial interpretation. Public choice theory provides the most effective tool for examining this form of claim. The last is the public choice theory. The character of the legislation process and collective decision making determine the form of legislation according to the public choice theory. It is the application of economic decision making models and their outcomes to questions that have historically occupied political science, such as the Arrow's theorem. One argument made by public choice theory is that knowing collective decision processes would help judges comprehend their role in the system. If individuals who get to frame the subjects debated and the sequence of voting, the agenda setters, have an unavoidable impact on all collective decisions, public law must be viewed differently than if it were a more impartial recording of community wants. A court's reference to the legislature's purpose becomes difficult in the light of such a conceivable consequence. With this, we reached the end of our lecture. I hope you had fun learning these concepts. Thank you.